I'm here to welcome everybody and help with safety announcements at the beginning. Thank you all for coming. I'm really excited to see what comes out of this event, and we welcome you in a spirit of openness, recognising it's very new. There is no wrong question. We're not expecting everybody to know anything or everything, and so ask you to embrace that spirit. This is not being live streamed, but the plenary sessions are being recorded, and the reasons for not recording the workshops is to encourage people to admit what they don't know. The workshops are designed to be practical, to explore and give participants tools to discover where and how automated decision-making and artificial intelligence is being used in decision-making by public authorities, to develop legal strategies to challenge unfair algorithm use of decisions, and identify and gather evidence to support their cases. But I'm assuming everybody knows all of this because it was on the invitation. There are upcoming events in chambers, including a session on the new minimum income requirement, a school inclusion project policy meeting, and neurodivergent children in the justice system, all available to find on the website. And thank you very much again for coming. There will be a link sent around afterwards to the recordings, and do join us afterwards in the hub for drinks and food and chats about all of the things that we don't get around to in the workshops. And on that note, it's my pleasure to introduce Shameem Ahmad from the Public Law Project, and she's the CEO. Thank you very much.
Thank you so much. I'm just going to stand up because it's always nice to hold on to something. Look, it's an absolute pleasure to welcome you all today to Rise of the Robots. I'm Shameem Ahmad, the CEO of Public Law Project. I'd like to thank Garden Court Chambers for collaborating with us on this event and hosting it, as well as thanking our exciting lineup of speakers, some of whom you can see and some of whom are scattered around. The purpose of this event is to deepen our understanding of the use of AI and automated decision-making by public bodies, and correspondingly, how we might challenge any misuse of that technology. This is the third instalment of Rise of the Robots. If you didn't see the first two, don't worry, like the best of sequels, you don't have to. But it is worth reminding ourselves of the context of that first event. It was held in 2020. A time when state use of algorithms crashed into the headlines. You'll remember that that was when A-level results were calculated using an algorithm that lowered the grades of poorer students, because it was deliberately designed to reflect the inequalities that already existed in society. Given that education is the route out of poverty for so many people, there is something particularly disturbing about that algorithm. 4 years on though, AI is talked about more than ever, but while large language models like ChatGPT grab the headlines, the state's use of automated technology continues to go unchecked. The dangers of AI are often imagined in some far-off dystopian future, where the world is taken over by robots, and indeed the title of this event is supposed to be ironic, because the harms of AI are being inflicted right now. UK public bodies continue to use algorithms to make life-altering decisions in the shadows, and those most marginalised in our society are at the sharpest end of the harm. Today, algorithms used by our public bodies deny people access to welfare benefits, housing and employment. Automated decision-making is being used by police forces, it's being used in education, it's being used to decide the future of migrants. These decisions and so many more affect an unknowable number of individuals. But each of those individuals has a unique experience that has led them to interact with a public body. And they each deserve to be dealt with fairly and with care by the state. We at PLP believe that the state is capable of tremendous good. The role played by PLP and shared by you all today is to ensure that the state meets that potential in an area where it is so far off course. Today, we want to help you develop the skills necessary to ensure that the state abides by the basic principles of public law in its use of this technology. So thank you for attending this workshop. I hope you find it useful and I hope that you enjoy it. It's my pleasure to hand over to the first panel.
Thank you very much to Shameem for opening up and introducing what we'll cover during this event today. I'm Mia Leslie and I'm a research fellow at Public Law Project, specialising in government use of new technologies. As Shameem said, the first Rise of the Robots event was held by PLP back in 2020, and making this the third event in the series. But it feels as if not more relevant and needed today as it did back then. AI and similar technologies are a hot topic right now. There is a lot of talk about this technology, how it will revolutionize the way we work, how we communicate, operate as a society, and what we're able to achieve. But a lot of this is future focused. The majority of both the optimism and fear of AI is rooted somewhere in the what ifs. And that's why the name of this event, The Harm Behind the Hype, is really useful framing. It allows us to clear some of this noise and to focus on what AI is being used for now, and in particular, what harm might be or already is being caused to individuals. AI is being rolled out everywhere, and the public sector is absolutely no different. The UK government, like many other governments across the world, is experimenting with and rolling out this new form of technology in public administration. And the experiences of introducing automated or AI technology in other jurisdictions, such as in the Netherlands and Australia, illustrates what we can mean by the harm behind the hype. So the robo-debt scandal in Australia, I think many people in this room have probably heard of this. It contained an automated system that was introduced to increase recoveries by the government of welfare overpayments. And a flaw in that method and system for calculating overpayments that was baked into the automated system ended up seeing huge amounts of money wrongly received from more than 500,000 benefit claimants accused of fraud. And the impact on many of their lives was catastrophic. The Siri scandal in the Netherlands is another example. It was used to detect possible welfare fraud by creating risk profiles. And the fallout from this scandal was huge. Again, thousands of lives were affected and public trust in the government was significantly eroded, so much so that the government at the time collapsed because of this. And I don't want to be alarmist. This is obviously the worst case scenario, and I'm not saying this is what is happening right now in the UK government. But both of these examples are situations where AI or similar automated technology is being used in the welfare state, and the mistakes that happened in both of those jurisdictions offer important lessons that the UK government has an opportunity to learn from. And they illustrate why events like this that's being held today are really important, and why conversations about what to be aware of and how to make sure the law can be useful to prevent situations like this occurring are so important to have. So what is the significance of using AI in government? There is lots of different technology that is being used, some probably not complicated enough, definitely not complicated enough to be called AI. But there is also technology that is complicated enough to be classified as AI. And as opposed to the private sector, it can have some significant specific impacts. The first is the element of choice when it comes to interacting with private actors in comparison to the state. Arguments can and have been made that the monopolization within the tech sector dilutes the difference between choice in private and public sector. But it does still exist. How would someone go about changing their welfare provider if they didn't like the way the service was being carried out? How would someone choose a different route or a different body for securing their immigration status if the process they had to engage with felt unfair? They just couldn't. Second, the cohort of people who are reliant on public services are a very specific and often quite marginalised group of demographics. These systems are being deployed to assist in decision making regarding people who state bodies interact with most, where the main cohort of people are marginalised in some way, especially if they are dependent on the provision of that service, such as welfare recipients and those in the immigration system. And where these systems are being developed and rolled out is often being driven by suspicion, and their use can be invasive, restrictive, and sometimes punitive. And I think this quote on the slide illustrates it quite well. Professor Karen Young, who's an expert in law, ethics, and information, said that we are looking at high volume data that is mostly about poor people, and we're turning it into prediction tools about poor people. So for the last 4 or so years, PLP has been conducting research into the use of AI and similar tech by public authorities to find out more about where it's used, what it's used for, how it operates, and how it impacts people. And this has been a resource-intensive process because the rollout of these systems is far from transparent. During part 2 of this event, we'll touch on how this opacity can be tackled and what tools there are to gather evidence on what's being used, why, and who it impacts. But for now, there is no systemic or comprehensive publication of information about how and why public authorities use automated systems. There has been some attempts to encourage transparency around government use of this tech. The Central Digital and Data Office and Centre for Data Ethics and Innovation created the Algorithmic Transparency Reporting Standard. And this is a screenshot of some of the reports, all of the reports actually, that have been submitted under it since it was initiated in 2022. The recording standard isn't mandatory. It is rolled out on an optional basis, and public authorities that use tools that fall within its scope are encouraged to submit reports under it. Which means that at the moment, key government departments that are using such tools have never submitted a single transparency report. The Cabinet Office's report on the use of a digital file review tool is only the 7th report that's been submitted under the standard, and the first since 2022. And like I say, none of the key government departments that we will look into later this afternoon that are using systems like this have submitted any reports to this standard. And the Justice and Home Affairs Committee recommended in its report in 2022 that full participation in this standard should become mandatory, and that its scope should be extended to become inclusive of all advanced algorithms used in the application of the law that have direct or indirect implications for individuals. The central government awareness of AI usage is also quite important. This quote is taken directly from the Cabinet Office response to a parliamentary question on awareness of AI and ADM in the public sector. And I think this further illustrates how deep-seated the transparency deficit truly is. As I mentioned, PLP has been doing work on this issue for around 4 years now. And as a result of our research and the research of others in this space, probably in this room, we have been able to construct and publish an online database that goes some way to acknowledging or bridging a bit of the gap around transparency and awareness of government use of this tech. The Tracking Automated Government, or TAG register, is an online database which actually launched almost a year ago in this room. The register offers some insight into the scale of government use of AI and automation. And at present, there are 55 tools on the register, most of which are used by the Home Office and the Department for Work and Pensions. The register provides details of the use of this technology, what it's used for, who's using it, how it works, and of particular importance to what the rest of my panel will discuss, whether there is any evidence of unequal impacts, and if so, for who and for which impacted groups. The workshops being held later this afternoon are a great opportunity to deep dive into the specifics of some of these tools from a range of policy areas in which they're being used. But zooming back out slightly to what this register shows us, as well as providing specific details on what's being used, it also provides a bit of an overview of the scale of use. It's not a full repository of government use of AI and ADM. It's likely only the tip of the iceberg. But even still, it shows us what type of purpose these tools are being developed for, which government departments are using or investing in this type of technology, and which groups in society are most likely being subject to ADM. Like I say, of the 55 tools, most are being used by the Home Office and DWP. 9 are being used by DWP, and 4 of those were introduced in the last financial year. And those 4 are based off the technical workings of a model that was introduced only a few years before that. So we can see with just a few years passing, the department is investing further into the use of these systems and rolling them out in more instances and testing them in different ways for different purposes. The Home Office, I think, uses 33 out of the 55 on the register. And I think this links really helpfully to the book by Joe Tomlinson and Jack Maxwell on experiments in automating immigration systems, because to have that range of tools being deployed in different areas within the department is to show a willingness to test, experiment on the way that they're working, their effectiveness and their accuracy. Over 80% of the tools that are on the register were only uncovered or more fully understood through the submission of freedom of information requests, which I think demonstrates the lack of transparency within this issue, and also I think links quite nicely to the session I'll be doing later on evidence gathering. And in terms of understanding how these tools work and who they impact, just under half have publicly available equality impact assessments and data protection impact assessments. Now, I won't go into loads of detail about why they matter, because I think the other panelists will do that in more justice than I can particularly do. But if impact assessments aren't put out into the public domain, it's very, very difficult to assess and understand what impact these tools are having and on who. And we cannot know for certain that these impact assessments are even being carried out and carried out to the level that they're supposed to be if they are not then put in the public domain for scrutiny or even disclosed to researchers, lawyers who are working on specific issues. So looking forwards, this increased use of AI and ADM is not happening in a vacuum. It's happening against a broader and changing landscape. The government's pro-innovation AI regulation white paper came out quite a while ago now. It came out in March of last year. And we are waiting for the consultation, feedback and analysis to be published. But what we do know is that the plans put forward in the white paper, which are light touch and, like I say, pro-innovation, will not introduce with them new statutory footing for what they are asking regulators, existing regulators, to do. And instead, it will rest on existing legal frameworks and the powers that existing regulators already have. At the same time, the data protection framework that we have in the UK, a key tool to understanding and providing safeguards against ADM, is likely to be watered down by the Data Protection and Digital Information Bill. And again, I won't go into too much detail on the proposed changes, but it's likely to affect subject access requests, the requirement to carry out substantial and meaningful data protection impact assessments, And it would also flip the presumption on protecting individuals from solely automated decision making. And this bill is currently making its way through Parliament and is expected to go through the House of Lords committee stage sometime later this month or early next month. All of that is to say, the landscape in which government is using AI and ADM is changing. And we'll need to be on top of the implications for that and what the changes for how we can safeguard individuals, to look for harm, and challenge the harm cause if it does occur. And in order to be sure that the law can work in the best way to prevent any harm from occurring or challenge it where it does happen. Thank you.
Thanks very much to Mia for that excellent summary of how depressing the landscape is. I think it's also really important to recognise that the pro-innovation approach is based on the fact that the UK thinks that the UK tech sector is significantly important to the economy, and that basically prompts a lot of the governance ideas around it at the moment. And so my session is on human rights and artificial intelligence, and up to now, everybody's been very focused on ethics, and ethics are great, but they have no teeth. So what I've been looking at over the last year is human rights and whether we can use human rights legislation to have some teeth. So firstly, I want to look at very briefly at what sort of technology feeds into automated decision making. So we talk about artificial intelligence and ADM, automated decision making. So surveillance technology, automated facial recognition, webcam, computer use, keystrokes, voice recognition, websites visited, content created. This is happening in schools and in workplaces. And then we have emotion recognition tech, using facial expression recognition, eye tracking, voice stress analysis, functional magnetic resonance imaging, so brain-computer interface, to identify lying, and also things like people's emotional mental health. I'm not commenting on the reliability of any of this at the moment. We also have profiling resulting from that, plus risk assessment and human-entered risk factors, including predictive algorithms. Many people will know of compass sentencing algorithms in the US. We have OASIS recidivism assessments in the UK. Welfare fraud was touched on in Siri case in the Netherlands, and migration and border control, which is currently looking at using a whole combination of these factors to assess risk. So in terms of human rights claims, there are some challenges. We know it's unlawful for a public authority to act in a way which is incompatible with convention right. We need a victim to be able to bring a claim, which in itself can cause some problems. A lot of people who are victims of abuses don't want to bring claims, they just want remedies, which may seem kind of counterproductive, but you don't want to be the poster boy for a challenge in welfare benefits if it means that all eyes are then on you in the future and it continues to impact on your ability to have positive decisions made about your disability benefits. Time limits and evidence gathering. Can the litigation be funded? Is it in the client's interest to bring the litigation at all? And then who is the public authority? And in terms of who is the public authority, there are obvious ones like a government department or a local authority. Naston, Cantlow and Wilmot, in the interest of efficiency and economy and for other reasons, functions of a governmental nature are frequently discharged by non-governmental bodies. This will depend on context, but it becomes interesting to consider whether non-governmental bodies performing a governmental function in the context of artificial intelligence and ADM becomes a public authority for the purposes of the Human Rights Act. The considerations that are taken into account include: to what extent is the body publicly funded? Is it exercising statutory power? Does it take the place of central government or local authorities? Does it provide a public service? And then whether and to what extent the state has surrendered or delegated any of its functions or powers to the organisation. And the issue that I think becomes more and more interesting over time is, could a public authority using a recommender or predictive algorithm to take a decision be said to have surrendered or delegated its functions to tech broke or number one or number two? I think this is going to raise really interesting questions, particularly when you look at putting a human in the loop. Does that solve the problem? Does the human effectively take back control? Or are we still stuck with this, I don't know what your algorithm is doing. Commercial sensitivity says you're not going to tell me, so effectively I'm surrendering control. The second thing that I think is important to look at in the context of human rights and AI is in accordance with the law. What does that mean? So from UK decisions, it's not just having a law that permits the but also whether the law is compatible with the rule of law, if we've got any left. And this means that it has to be sufficiently accessible and foreseeable for the individual to regulate his conduct accordingly. So if you have a risk-based algorithm that's assessing you against a set of criteria, should you be able to know what those criteria are so that you can regulate your conduct accordingly? And there have to be sufficient safeguards against the risk that it is not an arbitrary or discriminatory manner. And I like this quote from Lord Kerr from a case called Abigail, in which he gave a dissenting judgment, but the majority were overturned by the ECHR. And he said, the opportunity to exercise coercive power in an arbitrary or discriminatory fashion is antithetical to its legality. Very briefly to touch on necessary in a democratic society. And I'm not going to go through this case, but there's a lot of things that we want because they make life easier, or they apparently make life easier, but they're not necessary. So in terms of increasing surveillance for police, it's a nice thing to have, but we've managed without it for hundreds of years. So is it really necessary? And is it necessary in the face of the risks that we have as a society? And Weber and Saravia in Germany talks about there being a wide margin of appreciation given to states, but you need adequate and effective guarantees against abuse, and it's all context sensitive. So striking the right balance between individual rights and the benefits of new technology. So the proportionality and justification type element of many of the articles from ECHR. In as long ago as 2008, if a state claims to be take a pioneer role in the development of new technology, it bears a special responsibility for striking the right balance in this regard. And connected to that, we see a lot more talk about the precautionary principle entering into discussions about human rights and what steps are needed to make sure you safeguard people's rights before experimenting on them. And the final point on transparency, which was touched on by Mia, but I think transparency, the bit that gets missed out of public law quite often is this commercial interests of companies and how that interacts with state power. This is a CJEU case on a thing called iBorder Control. And iBorder Control is a system that's being researched at the moment where you input Europol data, Interpol data, a person will be interviewed by a robot. The robot will deploy emotion recognition to decide whether or not the person is lying. And then they may or may not scan your social media data using semantic analysis to decide things like whether you're a terrorist or whether you really need to go home, and that kind of thing. And Patrick Breyer tried to find information that has to be produced in an EU-funded project about ethics and human rights impact assessments, and was given some access but not full access, with the court finding that the commercial interests of the company and its consortium members who were funded outweighed the public interest at the research stage. So you can see some of the difficulties that we're going to have in terms of transparency. But there are some positives. So on facial recognition, we have the case of Glucan and Russia, which was July of last year, where the court found a breach of Article 8, said that in implementing facial recognition technology, there's a need for detailed rules governing the scope and application of measures and strong safeguards against the risk of abuse and arbitrariness. So you can see a theme coming out of some of this, which is rules, safeguards, not too much. But what they found in that case was that using facial recognition to identify somebody for an administrative offence effectively went beyond what was reasonable. But the case leaves two significant questions unanswered. One is, how do you define the notion of publicly available data that can be used for analysis, which wasn't answered by the court. And secondly, when is the general public interest or national security test justifying the use of surveillance technology met? So they are open for another time. Just very briefly on facial recognition, we know that facial recognition is racially discriminatory, and that comes from the work of Joybal and Winnie and Tim McEvery. We have cases in other jurisdictions on human rights. So in Poland, the requirement to provide biometrics at school for identification and lunch payment verification has been found illegal on the basis that there's no legal basis for others. And in Sweden, facial recognition technology in schools for the purpose of recording attendance has been found to breach not just data protection rights, also wider rights to privacy. So you can see the sort of breadth of use of these sorts of technologies, which is far beyond finding terrorists and paying for your lunch by using your face. It's not really necessary. I'm going to talk a little bit more about the Siri system in the Netherlands. So Siri was found not to, it's only a first instance decision, but it wasn't appealed. It brought the government down, and it is no longer in use. It was a system that was found not to strike a fair balance between the interests of fraud detection and the human right to privacy. It inadvertently created links based on lower socioeconomic status or an immigration background. It was only deployed in poor neighbourhoods. We're not seeing the same thing really in terms of tax evasion. Nobody's walking around Mayfair looking for people to target for tax investigations. The lack of safeguards, the interference was found because of the lack of safeguards. The interference wasn't proportionate or necessary for purposes of combating abuse and fraud. There was a lack of transparency, and this I think is really interesting. Neither the risk model nor the indicators of risk were public or known to the data subject. And there was no duty in the legislation to inform individuals that data had been processed or a risk report submitted. So when we're looking at some of the things that Mia had been talking about and the difficulty in finding out whether ADM is actually used, that would all seem to fall foul of that. Dutch also found that automated systems must meet the minimum protections of GDPR, or else they won't be in accordance with the law. And the absence of transparency also, interestingly, arguably results in the right to contest a decision becoming illusory. So your effective remedy disappears if you don't know the basis of the decisions. And then we move on to the predictive decision-making sorting hat. We know that predictive decision-making has already been found to be discriminatory in terms of visas, employment, exam results, predictive policing, welfare benefits, facial recognition, access to services, and housing allocations. There is a raft of ongoing litigation in the US over a lot of these things, including in respect to private providers and advert service provision in terms of content recommendation. Predictive decision-making tends to entrench pre-existing discrimination, embedded within training data and the questions asked of that data by humans. It's the case even if it's also more accurate than human decision-making. Blind belief in the data has the consequences of entrenching this discrimination and narrowing the scope of decision-making going forwards. And it's not a new problem. It goes back to probably even before here, but 90% of racial equality were informed by two senior lecturers at St George's Hospital Medical School that a computer program developed in the 70s and used in the screening of applicants for places at the school unfairly discriminated against women and people with non-European sounding names. The program gave a 90 to 95% correlation with the grading of the selection panel. And it wasn't introducing new bias, it just reflected that already existed in the system. The consequence of learning from the past and the previous selection panels was to import that discrimination into future decisions which weighed against women and people from sexual minorities. Wendy Chun argues in Discriminating Data that methods used themselves within big data and machine learning are specifically designed to group like people together, thus encoding segregation, eugenics, and identity politics through their assumptions. And so, although there are welcome attempts to make data fairer, many of the computer scientists that I've spoken to about this, firstly, it's their individual decisions on how to code for fairness. And also there is no accepted definition of what fairness is or what it means in the context of programming. So I want to finish with the quote from Discriminating Data, which is that social and legal codes, like their bite-sized counterparts, are not neutral, nor are all codes created neutral. Thank you very much.
Hello, I'm Yara Ali-Adib. I'm a lawyer at the Equality and Human Rights Commission. We are one of the regulators that the government's pro-innovation white paper set out to regulate in the sphere where there is no legislation, but fast developing AI. So the Equality and Human Rights Commission, it's the regulator of the Equality Act, that's the domestic piece of legislation, Equality Act 2010, and that has 9 protected characteristics within it, such as sex, race, age, disability, and also importantly, probably for our discussion today, 1.9, the public sector equality duty. Now, I think Nicola will cover these in a bit more detail, so I'll move on from that. So, thirdly, a definition of AI. Here is that from the EU AI Act that was leaked last week, actually, so hot off the press. It's my one and only slide because it's just a bit wordy, so you can read it at your leisure. So basically, AI has 2 elements. You could say the algorithm system, so a set of rules, and it's replicating, mimicking human intelligence. And it's that replication intelligence that sets it apart from an Excel document, for example. You're just using it to categorize data, but an AI will categorize and give an outcome. So how does that intelligence get acquired? So it's from machine learning. So a human will set a task and then train the machine on data. And so how can it discriminate? Well, as said, it's trained on data. And so there's an adage in Silicon Valley, trash in, trash out. So if the data is biased itself, the AI will just reinforce that bias really efficiently, because that's probably the main draw of AI, its efficiency. I think it's good to note that I think we have a bias to trust AI over a human decision making quite often. People think because it's on the computer, it has to be right. It's totally false. Like, we should not do that, because even though the AI, as I said, can be very efficient, if its data is flawed, it's going to give a flawed result. As Louise talked about regarding facial recognition technology, the police are using this technology, South Wales Police, very famously with the Bridges case, Court of Appeal case, and the Met, and they keep wielding out this report that they've got, the National Physical Laboratory report, that shows that actually the tech is getting more efficient and effective at spotting positive alerts. But even this report, their own, states that on darker skin and women, it's less effective at spotting positive results. So here we go, that's a bias. The AI also learns discriminatory correlations. So by that, I mean, an example would be in 2015, Amazon created machine learning to sift through CVs of mid to senior level for who should be put through to promotion. The data it fed was who had been successful in the past, and the machine gave the results, and it was mostly men. The reason why is because they realized that the people who then said are ideal candidates were male already from the past. So there we go. Again, it's reinforcing traditional stereotypes of bias within society, and very effectively. To note as well, even if you might not show a protected characteristic within the data set, the AI, because it's very good at spotting patterns, can basically use proxy data to profile. So if your CV, for example, doesn't have your name, but it might have your postcode, that could have a correlation to race. So AIs are really good at spotting that, and again, picking up discriminatory correlations. We're always saying AI, intelligence. Actually, it's just not that intelligent, obviously. It doesn't have human discretion. And so, for example, very clear way that it can discriminate is if you have a disability that affects your physical presentation and you're doing one of the joys of one of those online video interviews, and that you could be negatively marked down if you're not following the norm, and that would be discriminatory. So one of the key things that I've heard from Mia and Louise, and I'll reiterate, is the main difficulty is about transparency. So firstly, you might not even know, as we've heard, that an automated decision has happened against you. If you don't know that AI has been involved in the decision making, how are you to challenge it? And then even if you do know that it's been involved, how are you to challenge it? Because it's always wrapped up in the black box, which, as we've heard, it's got commercial sensitivity, intellectual property rights around it, and also potentially the black box algorithm can be too sophisticated even for the creator who made it to understand it, to explain it. There's no explainability here. There's no transparency. And that's why I'm very keen to talk about maybe later within the seminars a reversal of the burden of proof in these kind of cases where discrimination is alleged, because it really is one party has all the information, the claimant does not. So that's the main difficulty in bringing these kind of litigation, transparency. And also I would think about the fact that a lot of these, I know we're talking in a public sense, but in the private sector, a lot of these companies are multi-jurisdictional. So there's always a jurisdiction element in bringing these claims. There's quirk in the Equality Act, Schedule 25, which seems to be a major loophole, which is if it's domiciled in an EEA country, but operating here, it might not be captured by the Equality Act. Seems bonkers. I'd like to discuss that. And also, these private companies have alarmingly deep pockets. So we've seen in litigation against private companies, and actually the same will be said for governments, of course. It's sort of David and Goliath, you're up against the state, that the individual can be buried in litigation. They can take every point in to prolong litigation. So claiming will maybe drop it or settle if the precedent doesn't get set. So these are the difficulties that we have in this fast developing sphere. And we can see that how we come up with solutions. Okay, thank you.
We're now going to watch a recording by Ariane Adam from the Human Dignity Trust, and she's going to speak with this next session. Well, Yara's opened it, and then Ariane is going to do this presentation also on discrimination and equality in AI, and then I'm then after Ariane.
Hi everyone, it is a pleasure to join this conference, and I do apologize that I cannot be there in person. We are seeing increased calls for the adoption of a new legal framework that will be able to adequately regulate, prevent, protect against, and remedy the many harms posed by artificial intelligence and other forms of automated decision-making. The law is undoubtedly going to change in the next few years as these systems further proliferate and permeate nearly every area of our lives. However, we cannot and must not ignore the tools that we already have and the frameworks that can be used here and now to respond to the harms and the risk of harm that we are already witnessing. In our jurisdictional context, we are lucky to have the Equality Act 2010, which, albeit imperfect, is a comprehensive anti-discrimination act and can be used to respond to a lot of the instances of discrimination associated with artificial intelligence and other forms of automated decision-making. What I'd like to do in this segment is look at some examples of the ways in which these systems can discriminate and how the Equality Act can be used to respond to them. But before we do that, it is important to demystify artificial intelligence and algorithms in particular. They need to be seen as automated programs that use data, use a set of rules, and come up with a decision or come up with a factor that informs a decision. Discrimination most often arises where the rules that are used by the algorithm themselves consider a protected characteristic, or where the data that is used to input into the algorithm or to train the algorithm is biased or discriminatory in other ways. So let's look at specific examples. Let's take a hypothetical one first. Say that a housing authority in London offering social housing tenancies wants to develop an algorithm to consider the risk that a tenant applicant may not pay rent after they have lived in the accommodation for a number of months. Now, the housing authority may say, oh, actually, we think that Greek people pose a risk. Perhaps they have drawn that conclusion after almost 2 decades of a financial crisis. And I should say, I can use this stereotype and example because I am from Athens. So say that the housing authority thinks that there is a likelihood that Greek people will stop paying rent or will be late with their rent payments. They may design the program and design the factors that the algorithm considers to include nationality and Greek nationality specifically. What would happen then is you would have data, you would have an application from a tenant. The algorithm would consider that data against the rules of its design. One of those rules would include nationality, and it would flag tenants that put down their nationality as Greek as a red flag, potentially, that, you know, don't give a tenancy to them. That example would be an example of direct discrimination and can be challenged under Section 13 of the Equality Act, which protects against less favorable treatment because of a protected characteristic, read together with Part 4 of the Equality Act, which protects against discrimination in housing. Now, granted, it's quite rare to find algorithms, particularly algorithms used by public bodies, which so directly discriminate in this obvious way. Having said that, in 2020, Foxglove and the Joint Council for the Welfare of Immigrants successfully argued that a visa streaming tool used by the Home Office to automate the risk profiling it undertook of applications for entry clearance was racially discriminatory. Now, that tool used nationality as one of the factors. So at the first stage of the tool, some nationalities were automatically given a red rating. Although that case never went to trial, the Home Office did suspend the use of the tool as soon as the case was initiated by the two organizations. More often than not, however, the pudding lies in the data. The data that is fed into an algorithm can be biased, or the data that is used to train an algorithm can have gaps and underrepresentations leading to biased outcomes. So one relatively famous example dates back to 2018, when Reuters reported that Amazon had to stop using an AI system for screening job applicants because essentially the system had taught itself from the data that it was fed into it that women were not good at software developer and other technical jobs. From the data fed into the algorithm taught itself that women were not as good as men in doing those jobs. That would be a case of indirect discrimination, where the tool is using an, on its face, neutral process which disproportionately affects a particular group. In this case, it disproportionately affects on the basis of gender, And the reason it does so is because the data that is fed into the algorithm does not have sufficiently representative samples of women doing a good job at the software developer or technical posts. In our context, that type of practice from an employer, whether in the private or the public sector, could be actioned under Section 19, read together with Part 5 of the Equality Act. So those are the protections against indirect discrimination in the area of employment, which comes under Part 5. Another way in which the Equality Act can be useful is to challenge public bodies, and specifically challenge not only the fact that they may be using tools that are potentially discriminatory, but challenge them under the public sector equality duty and their duty to make sure that they have properly reviewed those systems before their deployment. This is what happened in the Bridges case in 2020. The issue there was with a facial recognition technology used by South Wales Police. The technology wasn't very good at identifying people of colour and women compared to white men. This was due, based on the evidence, on underrepresentation in the data used to train the technology. Essentially, the tool wasn't very good at distinguishing Black women from each other in the way that it could distinguish white men. That could lead to a lot of errors where the facial recognition tool can flag women of colour inappropriately when they haven't done anything wrong. The Court of Appeal recognised at paragraph 199 of its judgment that South Wales Police had never sought to satisfy themselves, either directly or by way of independent verification, that the software program did not have an acceptable bias on grounds of race or sex. And they did find a breach of the public sector equality duty. However, even where the data fed into the algorithm is apparently neutral, and the rules used by the algorithm are also apparently neutral, discrimination can still occur where the input and the piece of data that is used by the algorithm is a proxy for a protected characteristic. That can happen, for example, with tools that use postcodes, because of the way, particularly in London, but in other cities in England as well, postcode can often be a proxy for race or ethnicity because of the way that certain communities can congregate in specific areas of London. So, for example, last year, the Financial Times reported that UK financial regulators warned banks looking to use AI to approve loan applications, highlighting particularly that your postcode can be a proxy for race or ethnicity. Now, where there is evidence of a proxy being used, again, that can be challenged using the protections against indirect discrimination in the Equality Act. And where you're dealing with a public body, it can also be challenged under the public sector equality duty. I hope this has been useful as a crash course on the different ways in which discrimination can arise and the different ways in which the Equality Act 2010 can be effectively used here and now to combat it. I hand over to the rest of the panel for the discussion. Thank you.
Hello everyone, I'm Nicola Braganza and I'm a barrister here at Guard Court, and I specialise in discrimination and equality. And I've been specialising in discrimination and equality for now coming up to 30 years. It's not getting any easier, but yeah, we have to keep on bringing these claims. So that's what I'm going to speak about today. So I have 10 minutes and I was thinking, how can I make best use of those 10 minutes? And what I'm going to do is going to highlight 4 key points for you when you bring these challenges. So my 4 key points, because you'll be bringing challenges under the Equality Act, You can rely on the Equality Act in your private law claims and in your public law claims. You'll be relying on Section 149, which is the public sector equality duty, in your judicial reviews, and you'll be relying on Article 14. And there are differences in terms of Article 14 in the Equality Act. So sometimes you might be faced with exemptions under the Equality Act, and so you can use the Article 14 route to bring your challenge. Other times you might find that the Equality Act, because it sets out what the protected characteristics are, Article 14 is much wider in allowing you to also rely on other status. But caveat on Article 14, when it comes to justification, I'll be speaking about this in a moment, with Article 14 claims, case law really does, the courts do accord significant deference to what public authorities decide to do and how they do it. So in that respect, the Equality Act is more powerful. My 4 key points are, first of all, and I think you'll all know this, but it's important to bring out, do not underestimate what AI can do and does do. Key point number 1. 2, although discrimination in AI might on its face lend itself better to an indirect discrimination claim, don't not consider direct discrimination. So really important to think, because intuitively you might think, well, this is obviously an indirect discrimination scenario, but also see whether in fact there's a direct discrimination route, and I'll come to why that's so important. Number 3, key point number 3 for you to take away today, the burden of proof. In discrimination law, the burden of proof is an essential tool. Use and exploit that tool. It's all about making out your case on the face of it, and then it shifts. And it's so important, it shifts to the decision maker. The decision maker has to come up with the evidence. And if the decision maker doesn't have the evidence, you've made out your discrimination claim. And the fourth key point is get proactive. So start pressing, if you haven't already, press for that evidence, press for what you get in that evidence, and keep pressing and collect that evidence, because it may be in a claim that you run, you don't have it or you start getting it, but don't let that put you off, because in the future claim, you'll have the benefit of that evidence from the previous one, and you just have to go on building that evidence. So get proactive. Right. So, don't underestimate. So proxy discrimination, you've heard Ariane speak about this, and that is when closely corresponding factors, so I gave the example of Preddy and Bull, where civil partners are excluded from renting B&B rooms, they're available to married couples, so your corresponding proxy factor is civil partnership and marriage. The discrimination is on the basis of sexual orientation, so gay couples can't rent B&B rooms. So that's the proxy discrimination point. Similarly, predictive policing. Use postcodes. Well, postcodes on their face, and you've heard about this as well, seem harmless, but in fact, if those postcodes are targeting communities with areas with higher Black and Asian communities, or whichever particular community, then in fact, that is your proxy discrimination, and that is direct discrimination. So what happens then with AI? With AI, you get trained proxy discrimination. So an inherently discriminatory criterion is directly embedded and coded into the algorithm. So you have mortgage application assessments, again, the marital status correlation with repayment data, excluding civil partnerships, and in fact, that's just dressing up sexual orientation discrimination. Learnt proxy discrimination. So machines go off on a frolic on their own, and they draw their own correlations between data points, and the algorithm, rather than the human trainer, is creating the indissociable proxy. And then it gets even better. Latent variable proxy discrimination. Now, I can't recommend enough, this article is brilliant, and it goes into the detail of direct discrimination, indirect discrimination, and this proxy discrimination. So latent variable proxy discrimination is all about us not even having the ability to recognize the discrimination as humans, because AI is so far advanced in what it's developed. So the algorithms are infinitely better, read this article, than humans at amassing data and analyzing it for correlations. And whilst we can recognize when we are being indirectly discriminatory, we won't be recognising it when the AI is. And so it's so important. This links with my fourth key point about getting proactive. We don't know, I mean, we really don't know what's going on. So all we have to do, all we can do is press for the evidence on it. So don't underestimate. Quickly on this, I'm conscious of time, because I think this is all pretty frightening. Davis and Douglas, another article I recommend, set out a machine learning tool could learn a perfect proxy for race, a combination of variables that fully captures the correlation between race and measured recidivism, such that including race over and above this combination would have no effect. So the example given, formerly boys only secondary school, begins admitting girls in 2010. Employer recruiting says, well, the criteria you need to meet is if you're a graduate of the school and you're born after, for argument's sake, 1990. Neither is inherently discriminatory if applied individually, but if you combine the criteria cumulatively, you get indirect discrimination. So, intro to my second key point. So you might all be familiar with direct discrimination, the difference in treatment based on the protected characteristic. Indirect discrimination, when you apply neutrally a practice criterion provision and it disproportionately impacts on groups. I'm going to whiz past these, but you'll get the slides. And then Article 14, I've set out the stages. But my key point is don't rule out direct. And why do I say don't rule out direct? Because Section 13, if you can make out direct, there is no defence generally. I mean, if it's age, yes, it goes to justification, but generally there's no defence part. So you make out your prima facie case, the burden shifts, and then your respondent needs to demonstrate on the evidence that there is no discrimination whatsoever. Now, how is your respondent going to demonstrate from your algorithms that there is no discrimination whatsoever? So that's why if you can hang this on direct, it will make such a difference, because indirect, your respondent can say, well, I can justify what I'm doing. And I'll show you how that is really particularly frightening on indirect. Take the using geographical areas. Areas with larger Asian and Black populations are overrepresented. That leads to predictive policing. Predictive policing leads to increased policing. Increased policing leads to higher arrest rates. Higher arrest rates are fed back for the predictive policing. And the AI very smugly says, this confirms my original prediction. So you have runaway feedback loops in predictive policing. The model becomes increasingly confident, and that's your justification. So that's the end of your indirect discrimination claim. So that's why if you can bring it under direct, you don't get to that point. Okay, I'm going to need to wind up. Burden of proof, I've set out the authorities. So crucially important to use the burden of proof, because all you need to make out is a prima facie case. And another tool in discrimination is being able to rely on surrounding circumstances from which you can draw inferences. So if you have something you can draw inferences from, if you have statistics, if you have these patterns, you can draw adverse inferences to make out your prima facie case. If you can make out your prima facie case, the burden shifts. And if the burden shifts, it's then the respondent, the decision maker, the automated decision systems controller that has to evidence that there is no discrimination. And then the fourth point, and I'm a minute over, it's so important to get proactive. So we all recognise, and the courts recognise, that direct evidence of discrimination is rare. Obviously, in AI, it's going to be even more difficult. Plainly, establishing discrimination is difficult. Tribunals and courts should be prepared where appropriate to draw inferences. So this is the other important tool, the tool of the burden of proof shifting and the tool of drawing adverse inferences to make out your claim on a prima facie basis. So what do you do? And I'm really looking forward to Mia's session on evidence gathering. Get those equality impact assessments. Generally, equality impact assessments, from the ones I've seen, generally rubbish. So go back and ask more about these equality impacts, explore more, say, well, what are you doing about this? And just saying that there's discrimination, I've seen assessments like that as well. They recognise that there is discrimination and then seem to think that that's enough to comply with the public sector equality duty when it's not, because that's just not what the PSCD is about. Data protection impact assessment, make those freedom of information requests, make them now if you can, if you think that there's something within your potential, your client base, or there's something you've come across and you think there's more to it, because all of these things, as we know, take time. So you don't, if you can, start prepping it before you then at PAP stage, even before PAP stage, and then when you bring your JR, there seems to be less and less respect for the duty of candour in my experience, and litigating with cards face up. So be aware of that, be sceptical of what you're told and press on that. Where is the transparency? You've heard about that. Transparency is absolutely crucial. And particularly so in the AI context of discrimination. Ask different questions and don't be put off, because mere assertion is not enough. If you need an authority, use Smith. Smith says very helpfully, the Court of Appeal, you need contemporaneous documentation. You need to make out, you can't simply say there is no discrimination. And then Bridges, which you've heard about as well. Don't say, well, don't be satisfied or assured with the answer that, well, there is no problem here, there is no discrimination, because as Bridges sets out, that, however, it seems to us to put the cart before the horse. So have that in mind, that there is a need to properly explore and ensure that there is no discrimination, particularly where in this potentially incredibly powerful and harmful world of AI, it is likely to be even more prevalent, and it's likely to be even more easily hidden from us as clients and lawyers. Right, I'm sorry I've gone over, but those are my 4 key points. Thank you very much, everyone.
So the next thing that you're going to see is a short recorded piece from Abigail Holt, who's barrister at Garden Court, and her piece is on AI and product liability. She's been doing some work with the EU on product liability, and so is looking at it from a very different perspective.
Abigail Holt speaking, not a robot. I hope the conference is going well, and I'm sorry that I wasn't able to join you. I'm going to talk to you about artificial intelligence and product liability. My starting point is the Atlas of AI by Kate Crawford, where she talks about the fact that artificial intelligence often is neither artificial nor intelligent. Artificial intelligence uses systems which use huge amounts of energy and also require rare metals, often excavated from parts of the world where human rights are not respected. And systems are often not intelligent. We've all had experience of engaging with AI type systems which are full of glitches and do not work, and it's extraordinarily frustrating when there is no human in the loop to help resolve problems. I was reminded in preparing for this webinar as to how recent developments in AI have been. Alan Turing's work, which contributed to the end of the Second World War, was largely done in the late 1940s. For myself, my interest in this area has been developed by working with POPL, the Pan-European Organisation of Personal Injury Lawyers. I've been working with a group at Girona University, and also other Spanish lawyers and lawyers from Italy, Romania, Germany, as well as other UK lawyers, where we've been critiquing the new EU Product Liability Directive, as well as the proposal for the Artificial Intelligence Liability Directive. And really, the point of highlighting this is that the EU are streets ahead, it seems, to the UK, compared to the UK, in terms of trying to address the problems that AI systems will create. Having said that, POPL, as far as we know, are the only group that are critiquing the proposed changes from the perspective of victims and consumers. The other organisations that we know about who've responded are the likes of Google, large insurance companies, and so on and so forth. And so the overall story is that individuals and consumers are potentially at a huge disadvantage when it comes to AI. Now, in order to do a more thorough job in explaining this area of law, really you need to have an understanding of where the new challenges from AI will impact on the existing product liability law. You will probably remember from law school that this is an enormously complex area of law which engages parts of the law of contract as well as tort and the criminal law. But the overarching statute that provides the structure in this area is the Consumer Protection Act 1987. This slide, which I hope will be given to you in form of notes, sets out the basic provisions under the law of contracts, Sale of Goods Act 1979 and the Consumer Rights Act 2015. And of course, you will all remember from your times as students that the law of torts in this area emanates from a product liability case, namely Donoghue and Stevenson. But in terms of the law of tort and negligence generally, claimants have huge problems. They have the burden of proof. There are issues of foreseeability. The claimant has to prove causation. The claimant has to prove that they would have heeded warnings. And it's also particularly complicated where you have multiple tortfeasors, or you have products that include multiple components, which is often the situation with products that are increasingly incorporating AI. And there are huge problems where there is a complex supply chain potentially, or where goods are imported. There are problems when defects come to light after products have left the manufacturer's hands, and there can't be liability if a claimant cannot prove that the product was dangerous when it left the manufacturer. The Consumer Protection Act 1987 was designed to solve many of those challenges, and that liability is strict under Section 2 of the Act, so insofar as the claimant has to prove a defect rather than fault. But when the issue of AI is imposed on top of the existing legal framework, there are problems, because how does an AI product come to be considered in terms of goods, which usually mean physical things? Clearly, services, information and advice are not included within that definition, and therefore that raises the question about whether computer programs or artificial intelligence actually fulfills the definition of goods. Software embedded within goods which causes the goods or the product to fail may well be fall under the jurisdiction of the Consumer Protection Act 1987, but proving that and what the situation is when AI is delivered perhaps through software that's updated, perhaps on an ad hoc or even regular basis, causes complications. Overall, what you need to take away from this is that the architecture of the Consumer Protection Act doesn't really cater for AI. So where the AI is provided, or the computer equipment is provided through a USB stick, for example, and it's the USB stick, which causes a computer system to fail, then it may well be that engages the CPA 1987, but not if it's the information as embedded within an algorithm. Short, the AI has the potential to render our existing legal protection, so far as products are concerned, ineffective. There's a list there on this slide in relation to other limitations of the Consumer Protection Act, but overall, the takeaway is that artificial intelligence blurs the lines between products and services, and questions are raised in relation to liability connected to who actually writes the code. Will we as lawyers be able to trace that person or organisation? What liability will they have? What about the situation where updates arrive that effectively change a product? What happens when they arrive regularly? What happens if they arrive on an ad hoc basis? What happens if a product is second-hand but is still receiving updates in relation to software embedded within the product which changes the product? How does a claimant prove fault in relation to an AI system? The cost of critiquing code is going to be enormously expensive. What about experts? Who will claimants be able to go to? If they have the burden of proof in relation to malfunctioning systems, how are they going to be able to afford to do so? A claimant will also have the burden of proving in relation to potential tortious type claims or even contract claims, whether it's the output from the AI system that caused the damage or something else. What standards will producers of AI systems be expected to meet, and how will we know whether they have been satisfied or not? But as far as I'm aware, there is no system or indeed suggestions that those that create AI systems should be subject to their own type of professional regulation. Who's going to be under a duty to monitor AI systems? In terms of potential legal cases, how do claimants obtain disclosure of the details of defective AI systems themselves? Who's going to be required to keep the training and testing data sets? Who's going to oversee the robustness and accuracy of such systems? And what about potential defences that mesh with a claimant's duty to use an AI system? What if it's alleged that a claimant has not followed manufacturer's instructions? If a producer of a product or a system is not under a duty to retain the underlying data, what's going to happen when the system goes wrong in relation to interrogating the system and the data regarding the operation of the system? In short, a claimant is going to be at a huge disadvantage because it's the potential defendants that holds the electronic cards. I'm aware that the Office of Product Safety and Standards for the UK, had closed a recent consultation. It was closed, I think, in October of last year. The consultation was entitled Smarter Regulation UK Product Safety Review, but somewhat worryingly, the focus of that consultation was looking at a situation whereby the UK government reportedly wants to create real divergence from EU standards in the post-Brexit world and wants to concentrate on bringing goods to the market, online supply chains, as well as compliance and enforcement. And it seems to me somewhat obvious that the desire to bring on goods onto the market and issues to do with profitability conflict with the potential rights of those using artificial intelligence systems, which require investment in terms of making them work smoothly and properly. In relation to examples that I've included in the paper, I've looked at automated vehicles and also surgery. In the conference, one thing to think about is the proposal for electronic monitoring of people in the immigration asylum system, and I imagine also the criminal justice system, although I know less about that. It seems to me that as I understand the proposed design of the new electronic tags in inverted commas that will be used in the immigration system, that a lot of responsibility is to be put on the person under the bail conditions, whereby they are required to keep the device fully charged and to respond to prompts to input their fingerprint information. It begs all sorts of questions about what will happen if those systems, if the physical systems don't work. What will be the consequences if the prompt is not received because a unit is not working properly? How will the person subject to electronic monitoring be able to respond if they think that their system doesn't work properly? How easy will it be for them to contact the Home Office or the third party who perhaps will be asked to supervise those who are tagged? If the physical kit does not work, how will that impact on the rights of the individual under the tagging? From this position, it's really difficult to understand quite what will go wrong, but given examples of any product, but also what we know in relation to government computer contracts over the years, certainly it is likely that there will be problems and glitches. So I trust that this has been of interest and relevance to the conference, but I think the takeaway that I would wish to give you is that the artificial intelligence as incorporated within products is likely to be problematic, and the law of tort and the Consumer Protection Act as currently provided for does not deal with the problems that AI is going to generate. Thank you very much.
Thank you very much for being here, and to all of the panelists for giving up their time and presenting this afternoon. And we look forward to seeing you in 15:55 back in here. It's like being at a wedding. Thank you all very much for coming back promptly. We're going to start the second session, and in this session we've got Mia Leslie again from the Public Law Project, because she's brilliant, and Ravi Naik from AWO, which is a boutique legal consultant law firm and consultancy, and a video presentation from Shauna Concannon, who is a computer scientist at Durham University. In this session, we're going to look at the effective use of Freedom of Information Act requests, reporting to the Information Commissioner's Office, and then broadly speaking, how the technology works, and so what you would be looking at in terms of data, how bias enters systems. And then we will have a Q&A at the end. So with that, I'm going to say thank you very much, and over to you, Mia. Thank you.
Hello again. So I am going to be starting this evidence gathering session off by speaking specifically about Freedom of Information Act requests. So we've heard lots in session one from myself and the other panelists about opacity and government use of AI and ADM, and what that means for the information we know or about what it's being used, where it's being used. And one of the main things that I, within my work and PLP broadly, and just anyone doing work in this sector has been drawing on, is the use of Freedom of Information Act requests to just build up information and evidence about the use of AI in government and outside of government. So I'm going to caveat this presentation by saying that I and PLP do not at all have a 100% success rate with FOIAs. I have and still do experience refusals, and many of the issues that I'll highlight within this presentation are still ones that we encounter. Lots of the issues that people face in obtaining information is not completely circumvented by using FOIAs, but we have managed to build the tag register, spoke about in the last session, mainly by using this tool. And I think that goes to say that FOIAs do work and they can increase what we know about these systems and how they work. I also will use an example of PLP's work to illustrate some of what I'm talking about to make it a little bit more engaging and useful. So it was difficult to know where to pitch this session, as I'm sure this room are very experienced and have lots of experience in thinking about or submitting FOIA requests, or at least in using FOIA disclosure in their work. So I won't go through all the details of what FOIA is, how it works, the procedure, and instead we'll use this session to show three things. Why FOIA is particularly useful to understanding government use of AI and ADM, the specific challenges of the FOIA regime in this context, and what to ask for and why it's useful, drawing on our child marriage algorithm investigation. So why is FOIA particularly useful in this context? I'll start by stating the obvious. To be able to challenge unfair use or impact of a system, you need to know that it's being used, know it exists, and you need to be able to understand what the issue is, or exactly what part of that issue is challengeable. There are, of course, other ways to try and understand the answers to some of those questions. And Ravi is going to talk through SARS, so subject access requests. So I will stick to FOIA requests and why they're useful within this context. So FOIAs have a very broad application and scope. They are not limited, the questions that you can ask or the information you can ask for, to GDPR or data processing or collection. They also don't have to relate to a specific person, individual, groups, experiences of a system. They can be used to ask really broad questions about process, documents, data, stats, literally just a question. And they can be used to help identify where this technology sits in a policy or a process. So you can do things like ask for how the system interacts with the human decision maker, or where the system sits within a usual decision-making process. You can ask for the inputs or the outputs that go, like I say, in or out of the system. And you can also ask things like the format of the decision recommendation or decision support output that this will generate. So I say ask because you're not always guaranteed to then get that information. But even by asking, I think it's a very useful way of probing and showing interest as well into how this technology sits within the decision-making process itself. And you can also ask for specific documents. So earlier in the first session, people spoke predominantly about quality impact assessments, but you can also use FOIAs to ask for data protection impact assessments or any other impact assessments or types of assessment, because sometimes it's really useful to broaden what you're asking for and not just use really specific terminology in case that's not the terminology that's used internally by the department for the process that they undertake. So in terms of challenges, public authorities are using this technology for lots of different purposes. Earlier, I showed a screenshot of the algorithmic transparency reporting standard and some of the reports that have been submitted under that. And most of what was on there showed quite menial admin type uses of this tech, things like inbox prioritization or file organization. But they are also used in other contexts, which I think is mainly what a lot of us in this room are interested in. Specifically things like combating fraud or speeding up a department's ability to crack down on fraud. They're also being used in the immigration context to assist decision makers and caseworkers in departments often understaffed, overworked, have very strict time constraints. The use of tech in decision making in these specific contexts can be slightly frustrating when you take the FOIA presumptions of disclosure exemptions into consideration. So what I've done here on the slide is just show that so under section 31, public authorities can refuse a request for disclosure where disclosure is likely to prejudice the effectiveness of, firstly, prevention or detection of crime, which of course also includes fraud, and effective immigration control. Now, I am oversimplifying for the purposes of this presentation. These are qualified exemptions and the public interest in disclosure must be weighed up and assessed. But in reality, and at least what we have been experiencing, is that often these are being applied as blanket exemptions, at least in the first instance. And in that situation, you then are fighting against the fact that the information you're asking for is being engaged or engages these exemptions. So more on what to ask for and why it's useful. I'm going to draw on our sham marriage algorithm investigations to give some context to some of it. So one of the reasons, the initial reason why we even need to look into this system is because this screenshot, which I have on the slide, was part of a ICI-BI, so Independent Chief Inspectors of Borders and Immigration, report about sham marriages and immigration control. This was kind of buried in there. As you can see, it's not particularly highlighted. That highlight was done by me. That is the hook that we used to look into this system. And that is the hook that we used to reference in our FOIA request that we then submitted off the back of this. And this is just an example, but this is a really good way to start off a FOIA process when you want to understand more about a system. They will often refer to automated or AI systems, not by the terms that we're using today or the terms that I keep using, but more so things like model, decision support tool, decision recommendation tool. And that can be the first helpful sign or signal that there's a system being used that you might want to look into a bit further. So once you've identified something like that, you then want to think about what questions are most useful to submit within your request. So this is the questions that we did ask about this specific tool, and they're to try and clarify whether the system is still used, whether it is automated, whether it's being referred to as a model still, or if it's a different term that's being used. And then questions regarding protected characteristics and compliance with the Equalities Act. And then asking for relevant documents, like I say, an equality impact assessment, data protection impact assessment, or any other type of impact assessment. And internal policies, guidance, or operating procedures, which can link closely to the understanding how this sits within the decision-making process question. So we were lucky in this instance that we actually got disclosure of the equalities impact assessment. That doesn't always happen. And like I said earlier, out of all of the tools on the tag register, just less than half of them have documents like this that are publicly available. But what was useful about obtaining the EIA is that it included this graph, which shows which nationalities were impacted by the system that this algorithm was helping with. As an organisation, we were concerned that this might not be operating fairly because these nationalities represented on the graph didn't match up with the nationalities that are highly represented within couples giving notice to marry. It doesn't mean that we instantly know that there's discrimination there, but it's a hook, it's something that's useful to look into and assess. They also told us that there was 8 criteria being used, and because of seeing this impact on nationalities, we really wanted to dig into whether one of those criteria being used by the system contains nationality or a proxy for nationality. So in the equality impact assessment, we got this disclosure, which helpfully tells us that there's 8 criteria, but doesn't then show us anything about what those criteria are. So we still, just for ease of things, we still don't actually know what is behind that box. This FOIA that was submitted in this document that I'm showing you was disclosed at the end of 2020, and we've gone down a very long path of trying to find out what is behind this box. But from the equality impact assessment that we did get, it showed us that maybe there is some indirect discrimination on the basis of nationality. And on the back of that, we were able to start to think about and consider and do other research and work that led to information tribunal hearings, specifically about the disclosure of this criteria, and also pre-action correspondence with the Home Office regarding human review in the system, manual involvement, and how the criteria were decided. So even though this is not the golden example of disclosure through FOIA, I use it here today because I think it's a really useful example to show what you can get when useful, effective questions are asked, and to say that we wouldn't know anything about this system if we hadn't submitted this FOIA in the first place, because what we started with was just this hook from.
Thank you. It's more time to hear me talk. Okay. Thank you to Garden Court and Public Law Project for inviting me to be here. Having spoken at the very first Rise of the Robots, I do feel like somewhat of a veteran. My name is Ravi Naik, as you can see up on here. I'm a solicitor and the legal director of AWO. We are a specialist data protection AI governance agency, boutique. And as a veteran, and seeing this brave new world that's coming before us with AI, in 2024, we are embarking on a series of events about AI, automation and the law. And last week, we organised a conference on how the court may approach automation. We heard from a former Court of Appeal judge. It's really interesting. The audience was really quite mixed, including a series of solicitors from different practices. And one solicitor I knew that I was talking to from at the start of the event is from a commercial magic circle firm. And I was discussing with him his current workload to do with AI. It's very interesting. Thinking he must be very busy right now. He said to me, described it to me as like teenage sex. A lot of talk and not much action. While there is some truth in that and the distance between hype and new tech, it did make me think of today's conference, because the difference between the harm and the hype is really what we're here to talk about today. We are the lawyers at the other side trying to prevent or remedy harm that's occurring by automation. We've heard about this quite a lot of length in the opening sessions and the great work people did. If automation is causing it, it begs the immediate question what the action actually is. Because as lawyers, our job is on the action. Where is the action in automation? Well, one key issue we've heard about is data. Data is the foundation of automation and AI. The flower in the pasta, if you will. I'm going to give that some context. The current advancements in automated technology are happening due to machine learning, which can be roughly understood as a progression across 4 pillars following the pipeline that you see in the screen. Formula in this model is similar to a lot of the automation that's been discussed today. The harms. Personal data is the cornerstone. And here you find traction from evidence gathering. Can use data as a ground truth to, quote from the article that the slides from, meet tech companies where they're at, connecting regulation to what tech companies are best set up to do. So with that in mind, I want to focus on two issues related to data: requests for access, firstly, and then the ICO. So the starting point is the regulations. So we have two main regulations. This is the full title of the UK GDPR, which is very hard to find in Westlaw, and you also have the Data Protection Act. Note for certain public authorities, the law enforcement processing part of the DPA will apply. It has different features. We don't have time today to go into all that detail, but it's worth keeping that law enforcement part of the DPA in mind if you're doing access requests to certain authorities, and ensure that the other side doesn't try to say they are subject to the law enforcement parts when they actually are not. And keep in mind that this entire framework is currently undergoing statutory review with the Data Protection and Digital Information Bill. It's changing some fundamental aspects, including subject access requests. I won't get into the weeds because it's really complicated, but there's a lot of information on the AWO website, including, for example, the first analysis of how long an ICO complaint would take to resolve under this new regime. And from our calculations, the quickest it would take is 20 months from the day of a SAR to an outcome. Effectively make the entire process redundant. Anyway, for today's purposes, focus on these two regimes. It's very small print. Sorry about that. It wasn't like that when I sent it through, I promise you. Anyway, they're very complicated. The UK GDPR is subject to many articles, Data Protection Act, many sections, as well as many schedules. I'm not going to go through it exhaustively because that would be very difficult. I will instead start with some of the relevant bits for today. So, some of the definitions. The UK GDPR applies to the personal data of individuals. It's very wide. It includes identified or identifiable natural persons. So, pseudonymous identifiers. It places responsibilities and obligations on controllers. Controllers are very wide, including public authorities. This framework, this architecture is what sets around the structure of the data protection regime, including subject access requests. So, to subject access requests themselves. Most SARs are dealt with by Article 15 of the GDPR. You also have to keep in mind the law enforcement processing part of the DPA, but for current purposes, this is Article 15. This is where the meat is. Instead of trying to read all of it, I've just highlighted some bits that are important for you to consider. The first layer of the right of access is obtaining confirmation that personal data is being processed. That will obviously assist in making a request. So if you know there is a system in place, as Maya said, you can start to ask if your data has been processed in the system. Then the substantive element kicks in. You have the right to access what is being processed, as well as these additional elements, including purposes of processing and why, recipients of the data, information as to sources, and the existence of automated decision. And as you can imagine, this can be quite a powerful mechanism to start to understand what data is being collected, for what reasons, who it's being shared with, and so on. Start an evidential chain through the use of the subject access request. It's important to note at this point that subject access requests are not an absolute right. This is a qualified right and subject to exemptions. Again, we're quite constrained by time, but it's worth considering the schedules of the Data Protection Act. Schedule 2 in particular is important in finding a subject access request. What do you do, though, if a controller refuses to engage? Well, the use of data is a well-regulated environment in theory, as there is a specialist regulator that deals with data. ICO, they are the special enforcement chain. The ICO under the GDPR has wide and sweeping powers under the GDPR, including entering premises, ordering compliance, and to fine controllers. Also, individuals can make complaints to the ICO relating, including relating to failure to satisfactorily answer SARs. The mechanism for complaints is in Section 165 of the Data Protection Act. See here constituent elements. But despite that capacity and statutory footing for enforcement, the efficacy of the ICO has been questioned, from seemingly giving up entirely during COVID through to the actual statistics for people that are interested in facts of enforcement. And this inertia was summed up quite recently during the Data Protection Bill second reading of the Lords by Baroness Young, and she said the ICO's enforcement and prosecution record has not been sparkling. If, when I was at the Environment Agency, she was the chief executive, I had a lower level as those of the Information Commissioner had, I would think I had gone to sleep. Yes, indeed. And as the figures on the screen show, she has a point. Far from the GDPR resulting in strong enforcement that some people hoped, this period has seen a decline in the number of DP fines, with data protection notices hovering between 0 to 2 a year, despite over 35,000 complaints a year coming in. And that is a record to consider when you're advising or thinking about the ICO as a redress mechanism. Simply, the ICO is not an ombudsman. And I'm sad to say I've had similar engagement with other regulators, including some who are in this room. Sorry. Truth is truth. In addition to complaining to the ICO, though, individuals do have a right to bring claims to court for compliance orders. The form of such orders will be quite familiar to my public law colleagues. It's orders to start doing something. It's quite powerful. There are several cases with orders related to subject access. Of course, there are multiple problems with litigating that everyone here will know about and we spoke about earlier today. What do you do when you get the data? You get massive information in the form of normally incomprehensible spreadsheets. For the most part, it might provide a sufficient starting place to start a chain of inquiry, find patterns, third parties with whom data is being shared. Sometimes, however, you may end up with information overload. And it's important to know what this data means. We often partner with data scientists to help pass information. And I'm glad to say after me, we have a data scientist going into this in more detail. I wanted to just provide an example of what it's like when you partner with experts. Well, we took spreadsheets of data to create this. Now, the context of this is not public, it's private, it's online gambling. We started with a whole process where, through a number of SaaS to online gambling platforms and the third-party profiling companies they'd used, they gathered a profile of individuals. And this illustrates how the company built up a detailed picture of an individual's behaviour. To get here, we started with a client who had just a suspicion that his data had been used. And the SAR resulted in masses of data in the form of spreadsheets, but triggered chains of inquiries to other companies. We then had this massive information, thousands of data points, I think it was about 100,000 data points. And we then commissioned a data scientist to pass the information, pass the data, translate it into human language and visualize the output. That thought process of visualizing the output brings us back to our first slide. Using data, oh, that's not the first slide. That's the last slide. Anyway, the first slide was about system from the input data to the output. Thinking about how that output data is being used, thinking about how the data then translates into something automated and having it as an output to be used as evidence in court, just to help you understand how data is being used. I appreciate that was quite a sweeping introduction to data protection and some tools, but if this was bigger, you might be able to get in touch with me. Thank you.
Hello everybody, my name is Shauna Concannon and I am a lecturer in computer science at Durham University. In today's talk I'm going to be thinking about what does it mean for an AI system to be fair in terms that can be operationalised, and how might we go about looking for examples of how a system may not be performing fairly on all groups or individuals. What we would be looking for when approaching a computational system to think about what measures or evaluations we might be able to use to assess whether a system is discriminatory. What aspects of the data might we be inspecting, and how would we go about doing this? So first of all, what do I mean by AI? When I'm referring to AI throughout the talk, really I'm referring to systems that utilise data-driven systems to make decisions or predictions about unseen data. So this may be attempting to classify something or estimate, for example, risk. And the way in which the typical pipeline works is that we take data from the world. This data may be generated by humans, by systems, or a combination. When we're looking at people, we want to sample the data from a particular population, and this is sometimes done with differing degrees of care and attention. we have to also think about what it is that we're measuring. What are our variables? What are we looking to assess? We then would split the data into a train and test data set. And the training data is then used to train a model. So this is the data, we will iterate over the data to perform a particular task. We have the model output, and yeah. So there are many different types of bias that can impact on systems, and it manifests at various different points in the pipeline. So some of these are related very strongly to the underpinning data, the training data that is used, and what representation of the world really that provides. So we have to remember that bias really is kind of a fundamental basis of machine learning. So the whole point of machine learning algorithms is typically to discover patterns and differentiate between groups. So knowing that, we have to then think about, well, what are the types of biases that impact on individuals and groups in ways that are unfair and discriminatory, or lead to prejudicial treatment of individuals. And so historical bias is probably the one that we are all most familiar with, and this is the notion that the data that we are using will relate to the world around us. And sometimes this data will no longer reflect current contemporary reality. So for example, occupation data that looks at what roles were historically over and underrepresented by different demographic groups may not have leveled out to the modern day reality. So for example, medicine, we've seen huge shifts in the gender parity in this industry. So failing to account for this mismatch between data that was historically generated and a modern day society is one factor that we need to be really cautious and look for. A second factor, of course, is we need to account for the systemic discrimination that has shaped modern distributions. So when we're thinking about particular, so for example, crime, we need to look at the institutional racism that we know is in the justice system and how that's going to impact on the data that we have to train our systems. Another one is representation bias. Again, this rises essentially when we are defining and sampling our populations. So it occurs when the development population and the population that we train on either over or underrepresents certain groups, and then it subsequently fails to generalize well for some part of the population. So it's often necessary to train models with very large quantities of data, but sometimes this sort of sample data size is prioritized over the actual composition of the data sets. So we see this particularly in health data sets, for example, and one of the key issues here is that sometimes there is no demographic data available either. So if we, I think for a recent study showed that for cancer data sets using vision to detect skin cancer, only 2% of the data sets reported clinically relevant key demographic information such as ethnicity and skin tone. So often there is a lack, but this means that then the representations can't be inspected as clearly. So that's something that we need to be looking at. The other thing that's very important to think about is, what gets counted, and how are these decisions made? What transparency do we have around that? So as D'Ignazio and Klein say here, data must be classified in some way to be put to use. And by the time it even becomes data, it's already been classified in some way. So data is information made tractable. So what are the processes that have made data tractable here? So measurement bias arises when we're choosing, collecting or computing the features that we want our system to use. So when we're creating the labels that are going to be used to make a prediction. So typically a feature or a label is merely a proxy. So we're taking something observable that we can count, that we can measure, and we're going to use that in place of something that's more abstract, so a construct or an idea. So we need to think very carefully and inspect very carefully what was the design of the data, how was it constructed, what target variables and sampling was used for. If we look at example creditworthiness, what does that mean? We don't have anything that's a single observable measure that we can collect data to say if someone is creditworthy or not. So we have to take different factors and then compute an estimation. So or deem someone creditworthy or not. So unpacking the rationale behind these is an important thing that we need to do when we're looking at a system. What are the categories in our data? Are they observable or created? And if so, what was the rationale behind it? As well as measurement bias, we have then things that impact on the model itself. So we have things such as learning bias, which essentially is when the model amplifies choices, and this will often relate to the objective function. So what we're asking the model to optimize towards in the training process. We have the evaluation bias. This really is about when benchmark data sets are not representative of a population, and so the evaluation metrics that we're using aren't really telling us whether or not something is fair. And then we have deployment bias, and this arises when there is a mismatch between the problem a model is intended to solve and the way in which it's actually used. And so this often occurs when a system is built and evaluated as if it were fully autonomous, when in reality it's situated in a complicated socio-technical context. So they're the kind of broad different types, and then I'm going to think a little bit more about what would we practically do. So as I said, we have to think very carefully about the data, and then the other thing we can do is we can look at the outputs of the system, and we can do some simple calculations to look at error. So it's typically called error analysis. And if we imagine we have a predictive classifier, predictive model, it will either predict yes or no, and sometimes this will be accurate and true, and other times it will not, which gives us a matrix of outcomes. And using this, we can compute a few different measures. And so this is one way that we look at both the performance of a system, its accuracy, but potentially also some aspects of fairness. So if we take the example of the COMPASS algorithm, which was used to predict the chance of individuals reoffending, and it was quite a high profile case, and ProPublica investigated the measures that they were using, we can think through how this outcome matrix can be used to start informing this. So if we think about, we've got our basic error rate, so this is how often is the prediction wrong. We've got a false positive rate, so how often were non-offenders predicted to reoffend, and the false negative rate, how often were offenders predicted not to reoffend. And we can calculate this using the numbers, and essentially we can see, okay, one thing to think about is different metrics may align with different values and different concerns. So the false positive rate, here we have the defendants really are going to care about this. How often was a non-offender classed as high risk? Because that's going to impact on their life and their outcomes. And equally, if we're concerned with justice, it seems, rightly unjust if someone is actually, they're not offending, but they're treated as someone who is, and that might mean that they get a longer sentence or etc. The false negative rate, however, is looking at how often were offenders predicted not to reoffend, and the judges care about this, or someone who's wants to prioritise safety of society, etc., and a kind of protective element. And so these are distinct measures, and they're not always compatible. So bearing that in mind, we can see, okay, well, if we calculate across the whole thing, we can see, okay, the error rate isn't too bad. It's 33%. Well, I mean, that's not necessarily not too bad, but we know that that's the error rate. We've got the false positive rate, the false negative rate. You can look at those numbers and you can make a decision based on that. But then we might want to incorporate and investigate a little bit more carefully to look at the differential treatment. Now, in the COMPASS case study, they didn't use racial identity as a predictor, but what we see is that they did end up with very differential outcomes. And so we can calculate the error rate for these two groups. And while they may be relatively equivalent, the false positive rate is very distinct. And similarly, the false negative rate is also extremely divergent. So I think it's black defendants have a 1.9 higher false positive rate, and white defendants had a 1.7 higher false negative rate. So we can see that this is leading to very differential outcomes and unfair treatment. So this is kind of the first step of starting, but of course that relies on having demographic data available, and sometimes that's not the case. So we also have another example case study would be the Gender Shades Project by Buluemi and Gebru, and here what they found is that there wasn't demographic data available, and they were looking at the task of vision and facial recognition systems. And so they went through and they took two of the existing benchmark data sets and they labeled them to provide skin type annotations for subjects using the Fitzpatrick skin type classification system. And what they then found is that the benchmarks that were used to assess whether a system was performing well or not actually were really not representative, and therefore they weren't going to highlight that it wasn't performing well on darker skin typed individuals, particularly females. So first of all, they went through and they examined the distributions in those evaluation data sets. Next up, they created a more representational benchmark that could be used to test this system and future systems. Then they applied this to some commercial systems to evaluate the performance. Now they had that information to evaluate against, and they were looking at, again, did some then error analysis to assess how they were performing against different groups. So here, sometimes there's additional work that's going to be needed to be done in order to create the demographic information necessary to assess the system performance, because previously, and also another thing to mention here is that they looked at gender, and they also looked at so gender and skin tone, but increasingly I think the authors themselves have become aware that, well, things such as age may also have a factor. So we need to be thinking about what aspects we are investigating and what is represented in our benchmark. We can't be too overly reliant on a benchmark without also critically reflecting on what exactly it is testing. So there are numerous different fairness criteria that have been proposed over the years, each aiming to formalise a different type of fairness. So really we can make use of these, but we have to understand that it's impossible to satisfy all of them simultaneously. And so we need to be making sure that we are picking the best fitting fairness measures, testing multiple different fairness measures, and considering the tensions and trade-offs inherent when we're trying to make an assessment. And there are a number of toolkits available that can be used to help assist with running these different calculations of equalised odds, equal opportunity. So there's FairLearn, IBM's FairLearn 360. There's also counterfactual fairness tools such as Google What If, but there are a number of different toolkits to make it more accessible. But we need to think about the various definitions and the assumptions underneath them, and how much they relate to notions of fairness or discrimination. There's often a lot of interpretation that's going on and needs to be inspected. So in summary, I think the key things that we need to inspect the rationale and design decisions. So how are target variables defined and computed? We need to inspect the data and ask who is represented. Is demographic data available? Do we need to do additional labelling in order to be able to assess? What labels are used? How are annotations generated? Whose subjective assessments are integrated into the system and potentially introducing additional bias? We can conduct, simple error testing to start looking at, but we need to think about what we're testing. We need to look at the tensions between them, and we can then test against specialist benchmarks data sets. So like the parliamentary benchmark introduced by Buluemi and Gabriel. This is one approach for vision tasks. There are a number of distinct benchmark data sets and evaluation frameworks for different types of tasks. So for large language models, we have the holistic bias, which is looking at intersectional. There are ones that are specifically about gender bias. And this is emerging. There's more and more approaches being developed, but with all of them, we need to be critically reflecting on what it is they're evaluating. So I think I'll leave that there. Thanks very much, and do get in touch if you have questions.
I think the thing that stands out for me from that is a 30% error rate being acceptable. And I know it's higher in some circumstances for computer scientists, and I don't think they would. And on that, I think what we talked about earlier was asking if there are any questions, collecting some questions, and then answering them all at once. So if there are any questions, now is your opportunity.
Hi. Especially in the wake of the Post Office Horizon incident as well, I just sort of, it's come up a few times where there's a tendency to think that it's on the computer, it's come out in a whole lot of data set, therefore it must be right. What do you think needs to change in public decision making in order to move away from that, in order to have a more sort of credulous view of it?
Are there any more questions? We answer that one first.
So I've got a question about what you need to show in order to succeed in a legal claim. So you've got your maybe FOIA request for your SAR, and you've got maybe an explanation of how the algorithm works, and something has alerted you to the fact that it's a proxy for using a particular characteristic. So that indicates potential discrimination. You need to show in a particular case that it has resulted in discrimination and a disadvantage for that individual, with the very nature of the fact that it might include some kind of discriminatory input. Is that enough to challenge the algorithm?
Somebody at the back.
I just silly question, but and I think Shauna answers it to some extent. But are these issues about bias going into these learning processes? Are these interactive for AI? Some of what I hear in podcasts whatever suggest that it's not.
Any others? Shall we start with the first question?
Yeah, sure. I'm happy to take that
Sure.
first. You can also jump in. I think the post office scandal and even just any of the other examples I put on my slide of like what's being used in Australia and what's being used in the Netherlands, I think the only way you can really prevent a situation where people are allowing a technology that's not working properly to have free reign and just operate, and then 10 years down the line of picking up the pieces, is to think critically in the first place about whether introducing tech into a process is the solution. Like technology, AI, automation is not a silver bullet. It can help with efficiency, with cost cutting, but those positives of what it can do need to be weighed up with the very severe examples and case studies that we now know of what can happen when they go wrong. And that's a very kind of like high level point and doesn't really build into like what is necessary. But I think for that to be avoided, the use and introduction of tech needs to be proportionate to the aims and also not be treated as, like you say, a solution to all of the problems. And some of the kind of specific tools that were touched on in the first session, like data protection impact assessments, equality impact assessments, they're only one element of this whole landscape. But to properly think about what a system is going to do, how it's going to operate, who it might impact, and to have that done before it's rolled out, because these impact assessments are supposed to be done before the work is then carried out, should provoke and prompt the thoughts and possibly then the actions necessary to allow questioning whether it's useful, whether it will really achieve what we're after, and if not, what should we do about it before it's too late?
Yeah, it's a very, very good answer. Just quickly, I think on automation bias, I think most of the problems we see in Horizon and similar scandals is human error. And I think part of the issue is human understanding of what's actually gone on, and training and greater awareness of how things do go wrong is really vital. And I think the fact that we have this today and more people talking about it is really important. And also liability gaps and people being able to blame other people because of issues to do with when the computer said that, so how do you cure that? Which actually then goes to the second question, I think, which is about remedies, right? I mean, this is what AWO as a firm does. We deal with automation, AI, data and governance issues. And it really, for us, comes down to what's the remedy the client wants. So, if we bring a multifaceted claim, we'll try to find cures for the mischief technology is caused. So we'll bring different issues, Equality Act, and so on. We had a case before the Equality and Human Rights Commission, so it's configuring you, but about bias in the Facebook advertising system. So we said to the Human Rights Commission, here is some evidence of bias within this system. Here is where it has landed for jobs for women or excluding women and so on. And we gave them a range of remedies and an opinion from a Casey now, and the Equality Human Rights Commission haven't talked about it yet. Maybe we can have an update from my colleagues here. I'm sorry to just step into the second question. Yes.
Yeah, sure. I think what I was going to say in relation to the second question is how I interpreted that is the question is what's the threshold for being able to challenge algorithms and AI usage? And I think based off experience internally at PLP and also some of the research we've been doing of trying to pull together other people who are either lawyers in this space or are those that that instructs lawyers in the space, is that even though you have all of these tools for evidence gathering, often you don't quite get what you would need usually, or what you'd want usually, to feel confident and able to bring the litigation that you plan to. I think the opacity in the system, and I know we've said it lots of times, so we're very, very aware that how these systems are being rolled out is opaque, but I think it puts litigators in a position where they often would have to litigate blind, or at least compared to the position they would usually want to be into. So I think kind of answering where that threshold is not entirely decided. I think we're still quite early days in some of the legal challenges to these systems, especially in relation to how public sector uses these systems. And I don't think like a comfortable benchmark has been decided and reached as to what the threshold is and how you then guarantee you're going to be able to at least bring a challenge in that instance.
There's a real risk that we end up in the same situation that we ended up with the same fast track challenges in immigration and in the Unison challenge and that sort of thing, where you have a period of time where everything is unfair and unlawful, but each individual client can't demonstrate it because the evidence isn't. I think there's one glimmer of hope from human rights law, which is on disclosure in an Article 8 case on hospital records, where it said that because of the imbalance of power between the data that was held by the trust and the individual, there's a kind of shift in burden. I think that's probably the route that people are going to end up having to go down in the near future to try and get better access to data to bring claims, but I could be wrong.
It's a very good point about how long it takes for cases to get to court as well. I mean, we've had AWO for 4 years. The long tail of our cases now all getting to court. So we have 4 cases in the High Court this year. It's taken a few years for most of them settled or some sort of other resolution. But now at the point we're going to have a series of decisions and set precedent, maybe some of those sands will shift.
I haven't forgotten question 3, but do you want to respond?
I was sorry to put you on the spot about. Yes. And don't feel free.
It is on the spot. You're I would like to know about your cases.
Sure. Maybe
okay.
Should we try and deal with question number 3 and are bias issues intractable?
I don't know if I can answer that question, is it?
I think it would firstly take a lot more work to work through what the human impact is along with these systems. We're still talking about cases about rudimentary, let alone very sophisticated. It's taken a while for a lot of the precedent to weed through and understand what the biases are. I think you'll get that a lot more maybe in other states like the US, where there's more technology used, but a lot more litigation, but then also different laws. So it's going to take a while for it to get through. I don't think it's an insurmountable problem. It's just
Are you thinking about the creation of synthetic data and that kind of thing? Are you thinking about the creation of synthetic data?
I don't know.
So when you haven't got enough data or you've got not enough representative data, you can create some data to fill the gaps in it and then run your machines over this created data, which I think brings a different set of problems. I wonder whether the actual answer is that there is always going to be bias, because if you ran a survey across this room about what was fair in any given circumstance, you will get a range of responses. Coders like to think in binary terms. I don't think you can use binary terms for human beings. So there will always be a degree of bias, whether it's bad bias or good bias is a separate issue. And whether it's an acceptable level of differential treatment is also a different issue.
supplement that with another question. So one thing we're seeing as an NGO is that companies are starting to argue they need to collect additional sensitive special category data. So ethnicity or sexual orientation or religion, which they haven't in the past, but in order to demonstrate that their training data sets are not biased. Do you think, is that something we're going to see? I mean, I think that's coming into the Data Protection and Digital Information Bill as well. There's that sort of argument that that will no longer have the same protections around it because it is seen as necessary in order to prevent automation bias. Is it anything in that direction, thinking about what that might mean?
Should we take that other question and then
There was a question here earlier that I'm sorry, I missed.
Yeah, so it was a comment actually, if that's okay. So my name's Ariane Davis, and I'm from Mind, the mental health charity. So I was just thinking this is a tale of numbers that we've actually seen before. So, for example, in the development of early psychology, you know, Freud and all that had these concepts that could really be tested one way or another, and they found, you know, they didn't necessarily get the same professional respect as doctors, and they were in the context of largely industrialising society. They turned to numbers and quantitative assessments in order to be taken seriously. And for example, in the development of the IQ test, it was originally meant to be a sort of modular assessment that highlighted people's weaknesses, and the whole point of it was then to work on those weaknesses in order to help them to sort of catch up. And it was never ever meant to be added up as a whole to give you a sort of finite number. But from there, it was used in exactly the opposite way of what the original psychologists had meant. So, for example, it would be administered to children to condemn them to a life of having no education instead of actually helping with the bits that they don't work on. It was used to as a cut-off, administered to people immigrating into the United States, administered to people who didn't speak English and got very low scores. In Sweden, it was used as cut-off just in the eugenics programme to decide whether people were forcibly sterilised or not. And I think, you know, that's a tale of what the numbers tell us when we're dealing with human beings, whose control the numbers are in, and what are they trying to use it for. And that's why the questions of, you know, power and equality that we're trying to chip away at the law and can deal with in terms of our public law sort of cases. But behind all that, that's all the scary bits.
I think we're going to have to go very quickly because my timing is falling.
I'll let you take it.
I'll very quickly on that last statement. It's very, very good point. I always say that the GDPR is not a privacy regulation, it's a power regulation to help people give some power and power and balance. It's a really good point about more data to cure bias. It's a bit of a problem. We're looking at this in the data protection bill as well as in the gambling context, where gambling companies say they need more data to be able to spot vulnerable people, but they already have huge amounts of data to target vulnerable people. And what we say is maybe a solution is some sort of ombudsman or framework that allows oversight.
Because I'm terrible at timing, I'm going to be 15 minutes over. Sorry about that. The break is downstairs. I'm going to cut short the wrap up and conclusions by at least 10 minutes. So what I'm going to ask is if we could have a short break of 15 minutes and then to go to the workshop rooms.